All right, welcome to this, the third lecture in our series of lectures to prepare you for the MPRE. Having dealt with the basics of lawyer regulation, the basics of the lawyer-client relationship, let's in this relatively brief lecture turn to the business of lawyering by first starting to talk about the law governing law firms, lawyers associated in a firm as associates, as partners. What are some of the obligations that apply in that context? And then let's turn to advertising and solicitation, what the limits are on lawyer speech, lawyers reaching out in an effort to get business.
The business of law. Now that we've talked about the lawyer-client relationship, let's talk about how lawyers actually organize themselves from a business perspective and make money. We'll talk about law firms and the obligations of supervisory lawyers. We'll talk about subordinate lawyers, the limited safe harbor that's available for those lawyers, and from ethical charges. We'll talk about non-lawyer assistants. This is paralegals, investigators, secretaries, and whatnot. Restrictions on the right to practice, particularly in connection with settlements and with lawyers leaving law firms. Professional independence. We'll address the extent to which non-lawyers can receive monies for referring referring clients to lawyers, or the extent to which they can actually be equity participants in a law firm. Sale of law practice, getting out of the practice essentially, and then law-related services when, for example, a lawyer might want to be a body shop owner or sell financial or estate planning services in addition to legal services. Then we'll talk about advertising and solicitation. Obviously, this area of law changed dramatically in the wake of Bates versus Arizona in the late 70s. We'll talk about the First Amendment rights lawyers have and the regulations that are still allowed. We'll talk about in-person solicitation, the extent to which a lawyer can slide a business card in between the toes of a patient at a hospital. Obviously, that kind of coercive contact is not going to be allowed. We'll talk about fields of practice and specialization, and then finally finish up by talking about firm names and letterheads.
All right, first let's turn to law firms. What obligations do supervisory lawyers have to make sure that the other lawyers in the firm are complying with the rules of professional conduct? Subordinate lawyers, what are their obligations, and what safe harbors are available to them when they follow the directions of a more senior lawyer? We'll then talk about non-lawyer assistants, secretaries, paralegals, whatnot. Then deal with restrictions on a lawyer's right to practice. Talk then about non-lawyer participation and ownership of law firms and preserving professional independence. Then we'll turn to the sale of a law practice when a lawyer just wants out. And then we'll finish up very briefly with lawyers who provide law-related services in connection with their legal services.
Law firms. Okay, first of all, supervisory lawyers at a law firm. Who qualifies as a supervisory lawyer? Well, obviously, if we're in a law firm that's a traditional partnership, then partners would be considered supervisory lawyers. But these principles also apply to lawyers who are direct supervisors of subordinate lawyers, even if, for example, they might not be a partner, they might be a senior associate or something. So when we're talking about the obligations of supervisory lawyers, we're not limiting it to partners and shareholders of the law firm enterprise. We're also talking about direct supervisors. What's the basic rule or the basic duty of supervision? They must make reasonable efforts to assure that subordinates and other partners are in compliance with the rules of professional conduct. Now, they're not strictly liable for violations, but they've just got to make reasonable efforts. So there's a duty of reasonable care. A supervisory lawyer is actually responsible for a subordinate's misconduct only under three circumstances. They're not strictly liable, but they are liable if they either ordered the misconduct or, after learning about it, they ratified the misconduct, or the lawyer knows of the misconduct at a point in time when harm can be avoided, but the lawyer, the supervisory lawyer, takes no reasonable remedial action, does nothing to fix the consequences of the misconduct. What about subordinate lawyers? Now that we've talked about supervisory lawyers, the basic principle here is there's no Nuremberg defense. And of course, you all know Nuremberg. That was the site of the war trials in the wake of the Nazi atrocities of World War II. Many underlings in the Third Reich contended that they killed people, set up concentration camps and death camps because they were just following orders. Well, that didn't work for them. They hung from the gallows, many of them. And that's the same fate, at least metaphorically, that would be met by a subordinate lawyer who just follows orders. Now, having said that, there is a limited safe harbor. If a subordinate follows a supervisory lawyer's reasonable resolution of an arguable question of professional duty, resolution of an arguable question of professional duty, then that subordinate lawyer is going to be shielded from ethical consequences. Non-lawyer assistants, paralegals, secretaries, etc. A supervisory lawyer must make reasonable efforts to assure that a non-lawyer's conduct is compatible with the obligations of a lawyer. Keep in mind that non-lawyers are non-lawyers, so they are not subject to the rules of professional conduct. So this, in essence, says that the supervisory lawyer of the non-lawyer needs to make sure that these non-lawyers comply with the rules, even though their breaches can't be enforced against the non-lawyer. They can be enforced against the lawyer if the lawyer does not take reasonable efforts. Now, again, the lawyer is not strictly liable for any non-lawyer's breach. A lawyer is only responsible for a non-lawyer's misconduct if the lawyer orders the misconduct or ratifies it after learning about it, or once the lawyer knows about it and can avoid some harm, but he takes no reasonable remedial actions. Again, that's not strict liability. It's liability for failing to do something about it or ordering the misconduct. Restrictions on the right to practice. A lawyer can't practice law in a firm which restricts his post-termination right to practice. So you can't have a non-compete, for example, in a law firm partnership agreement. Now, having said that, it is okay to restrict a lawyer's right to practice after termination as a condition on receiving retirement benefits. Likewise, a lawyer can't ask another lawyer to restrict his right to practice in settling a lawsuit. So, for example, if you represent a big chemical company, you can't settle the case on the condition that the lawyer never sue the chemical company again. Now, you can put restrictions on a lawyer's right to use documents or something in the wake of a lawsuit, but not on the right to sue the defendant again. Professional independence. A lawyer can't allow a person who recommends employment or pays him to direct his professional judgment. That's true if the person paying him is an insurance company or someone's mother. You've got to serve your client, not whoever's paying you. Fee splitting. Can you split fees with non-lawyers? The answer to that is no. You can't pay a tow truck driver to bring you a case, and you can't share a legal fee with a tow truck driver or any other non-lawyer. However, having said that, it's okay to share fees in the context of paying death benefits to a dead lawyer's estate. You can pay compensation or retirement plans to non-lawyer staff. You can sell a law firm and have the proceeds paid to the dead lawyer's estate. And you can share court-ordered fees with a nonprofit organization that hired the lawyer. Like, for example, if the ACLU hires you to handle a free speech case and you sue a city and you get an award of attorney's fees, you can share those fees with the nonprofit organization that hired you, the ACLU. Again, not a big exception to this prohibition, but one that's important in that context. Association with non-lawyers. A lawyer cannot enter into a partnership if any part of the partnership constitutes the practice of law. So, for example, you can't enter into a partnership with an estate planning accountant or a broker if any part of the partnership constitutes the practice of law. And then finally, a lawyer cannot practice law in a firm if a non-lawyer owns an interest in it, if a non-lawyer is an officer, a director, or a non-lawyer can direct the professional judgment of a lawyer. For that reason, we don't see lawyers working at H&R Block. Why? Because non-lawyers own H&R Block, so a lawyer couldn't practice in that firm. Sale of a law practice. This allows essentially lawyers to get out of the practice. And the rule here is it's okay to sell a practice, including goodwill, if the seller ceases private practice altogether or in the field that the lawyer sells. The purchaser takes all of the clients in either that field or in the lawyer's practice, or finally, the client's fees don't increase in connection with the sale. Finally, law-related services. This is all about providing ancillary services in conjunction with legal services. For example, suppose you want to offer estate planning and tax filing services, for example, or if you want to be a lobbyist in addition to doing government relations. The rules, these provisions do is say that the rules apply to both the legal and non-legal services if the services are not distinct. All that means is, like, for example, the obligations of confidentiality, the obligations of loyalty, all of those lawyer rules are going to apply to the lawyer when he's providing non-legal services if those services are not distinct from the legal services. And that would, for example, be the case if the lawyer was doing estate planning and tax work. I mean, it's hard to draw the line. But if the lawyer is providing body shop services in addition to handling personal injury cases, those services are distinct, and the lawyer wouldn't have an obligation of confidentiality, for example, with regard to the car repair services. Lawyers got to assure that the clients understand that the rules don't cover distinct services. So when the lawyer's talking to the client about the car repairs, that's not going to be protected by confidentiality. And of course, the lawyer has got to comply with Rule 1.8a regarding the non-legal services. That, you may remember, is the rule that governs doing business with a client. There are lots of hoops that a lawyer needs to jump through, and the lawyer is going to need to jump through those hoops in order to provide those law-related services because the lawyer is doing business. So, for example, if the lawyer is going to repair the client's car, that's a business transaction with the client, and the lawyer's got to jump through all the proper hoops. Advertising and solicitation. Of course, few things are more controversial in the law governing lawyering than advertising. The whole landscape, literally and figuratively, changed after Bates versus Arizona in the late 1970s. Which, of course, found that lawyers have a First Amendment commercial speech right to advertise. Blanket prohibitions violate the First Amendment, according to the Supreme Court of the United States in Bates. So as a result of that, billboards popped up along the landscape, and lawyers began to advertise, and advertise they did until we get to the point where we are now, where lawyer advertising is ubiquitous. So what's the regulatory landscape in this regard? Well, of course, the starting point for this is the First Amendment. That's what brings us to this discussion in the first place. Lawyer advertising is commercial speech that's subject to intermediate scrutiny under the First Amendment. And under an intermediate scrutiny approach to evaluating lawyer ad regulations, the government has got to have a substantial interest in regulating. The regulation has got to directly and materially advance that interest, and it's got to be narrowly tailored to address the harm that
has given rise to the regulation in the first place. So that's what the First Amendment requires. And all of the advertisement regulations that we're going to look at here have all passed muster under this intermediate scrutiny analysis. All right, so what are the basic principles regulating lawyer advertising? This is the overarching principle. No false or misleading communications of any kind. You can't put a billboard that is false or misleading out in a neutral ground or out along an interstate. If a client is sitting across your desk in your office, you can't mislead or say something false to that person. This includes unjustified expectations and unsubstantiated comparisons. You can't say you're the best lawyer in New Orleans. That's an unsubstantiated comparison, and that would be false or misleading. Some technical limitations and requirements for ads. A lawyer must obtain a client's consent to use the client's name in an ad, and all ads must identify by name and address at least one lawyer responsible for the advertisement's content. A lawyer cannot give anything of value to someone for referring a case, so this means no referral fees, no paying your friend for sending you the personal injury case. You can't give anything of value for a case. However, it's okay to pay the usual charges of a legal services plan. It's okay to pay a qualified lawyer referral service. Now, by qualified, that means it's run by some bar association, not by some for-profit referral service. And reciprocal referral agreements are okay, as long as they are non-exclusive, as long as the client knows about them, as long as they don't interfere with the lawyer's professional judgment, and they have some definite duration. So you and I can enter into an agreement under which I'll send you all of the personal injury cases that walk through my door, and you'll send me all of the domestic relations cases that walk through your door. And that's okay, as long, again, as it's non-exclusive, we tell the clients about it. And by non-exclusive, I'm free to refer cases to other lawyers. I'm not bound contractually to send them only to you. This assures that the lawyer thinks about where she is referring cases and just doesn't do it as a matter of contract. Okay, that's advertising. And when we're talking about advertising, we're just talking about broadcast advertising that is not coercive. It goes out to the world, and when it goes out to the world, people can either read the ads or ignore the ads, and that's what we're talking about by way of advertising. When we're talking about solicitation, however, we're talking about more targeted communications that are directed toward an individual. Now, these are more coercive because somebody is in your face saying, please hire me as your lawyer. And because they're targeted at an individual, and they are more coercive, the targeted individual would feel less comfortable just telling the lawyer no. Because of that, the First Amendment allows states to prohibit and regulate more strictly solicitation as opposed to advertising. So what are the rules? Well, first of all, no in-person live phone or IM chat contact with a prospective client. Can't ring somebody's doorbell and say, can I be your lawyer? You can't call them live on the phone and say, would you like me to be your lawyer? And you can't go into a chat room and ask them if they want you to be their lawyer. Now, that's the general rule, but this rule only applies if there's a significant motive of pecuniary gain in making the contact. You can approach somebody to handle a case for them pro bono, and this happens with public interest groups like the ACLU. Law school clinics approach people and offer to handle cases for free. That's okay. Why? Because the real motive is usually some educational purpose or some pro bono policy purpose. Now, there are some contacts that are allowed, in-person or live phone contacts that are allowed if there's a prior professional relationship. You can call, for example, your prior clients and tell them about a new drug case that you're starting up, close friends, family members, and other lawyers. So you can approach
a lawyer for State Farm and offer to do work for State Farm. You could take them out to play golf at the country club. That's all allowed because the thinking is that the other lawyer is not going to feel as intimidated by the in-person contact, and the other lawyer can just tell the solicitor no if she's not interested in talking. Targeted mail is okay. This is when you send a letter to a person known to need legal services. It's different from a broadcast that goes out to every house, for example, in a neighborhood. This is targeted to people known to need legal services. For example, some law firms scour the newspaper for recent DWI arrests and send letters to those people offering services. That's okay as long as it's not coercive or harassing, or the prospective client says no. Now, the only technical requirement for these targeted targeted mail, and includes email, is that it must be labeled on the outside as advertising material, and that's got to be on the outside of the envelope, on the ray line of the letter or the email. Now, you don't even have to do that if this is you're targeting somebody who it's okay to solicit. That is, one of these people with a prior professional relationship, etc. Last point on solicitation is that a lawyer participating in a group or prepaid legal services doesn't get himself in trouble if that group or plan went out and solicited plan members through in-person contacts. Fields of practice. Suppose you want to tell people that you are a personal injury lawyer or a criminal lawyer. Can you do that? Yes, of course you can do that. If you're certified as a specialist, you can claim that you are a specialist only if the certifying body was approved either by the state or by the ABA. This prohibits, for example, you and I from getting together over a beer and deciding to certify each other as certified specialists in beer law, only if the certification is by some reputable, and again, the ABA or the state, is that allowed. And of course, the rules always allow lawyers to say that they're either patent lawyers or admiralty lawyers. Okay, last point on advertising and solicitation, firm names. You can't have a name that implies that you are in a partnership if that's not true. You can keep a partner's name after the partner departs. For example, Cravath, Swain, and Moore. All of those guys are long departed from the firm, long dead. It's okay to keep their names in the firm because they are both dead, and all three are dead and retired. You cannot use a lawyer's name in the name of the firm if the lawyer is no longer practicing with the firm and holds a public office during a substantial period. Trade names are okay as long as they don't mislead and they don't imply some connection to the government. So you can open up a lemon law clinic, for example, or a bankruptcy law center. Again, that trade name is okay as long as it's not misleading. In a multi-state firm, you have to identify where the lawyers are admitted to practice. That's usually done with asterisks and daggers next to the names on the letterhead. That is acceptable. And finally, a firm could claim association if they have a regular ongoing relationship, however, but they would be considered a single firm for purposes of conflict. So if you have a regular ongoing relationship with another firm, with several firms in a network, for example, that's okay. You can claim that association as long as it's regular and ongoing, but keep in mind that once you do that, you're a firm for conflicts purposes, and even though the firms might be separate from an entity standpoint, they'll be treated as a single unit for purposes of imputation of conflicts.
Okay, well, that concludes our lectures on as I said, our relatively brief lectures on the law as a business. We'll now turn to our second to last lecture that deals with the different roles that lawyers play and the different obligations attendant to each of those roles.